if you win, how do you reorganize a district attorney's office?
That question is what a lot of people are concerned about. I know there's been a lot of concern, in particular from the prosecutors and staff that are there already. And I don't have any intention of coming in and doing a major reorganization of the office. You know, I recognize that I'm a Harris County prosecutor. And so for a lot of people, there's been concern that, well, this guy from the Harris County DA's office is going to come down and bring a bunch of his cronies and buddies with him, and then he's going to just totally change the way that the Galveston criminal justice system works. And that's not my intention at all. In fact, I've tried to use every opportunity that I had to reassure the prosecutors there and the staff there that I'm not running for DA because I think they're doing a bad job. I'm running for DA because I think there needs to be new leadership in the office, that there's good people there and that they're doing a good job, but I think they could do better with a different leader that has a different leadership vision and a different leadership style. So I don't, at this point, anticipate any major reorganization of the office.
How long have you been with the Harris County DA?
10 years as a prosecutor and 2 years as an intern.
So you've already seen a transition.
I've been under 4 DAs.
Right.
And so I was the last class of pre-commits sworn in by Johnny Holmes before he retired. And then we've had Rosenthal. There wasn't a big change in organization from that. And then Ken Magazine came in, and then Judge Likas came in. And there's been some pretty big structural reorganization under Judge Likas. So having served under 4 DAs gives you a broad spectrum of experience in management styles and leadership styles, and you see stuff that works really well and you see stuff that doesn't work really well. So it's kind of nice to learn at somebody else's expense.
Yes.
Leadership style, spell that out for me, and particularly how yours would depart from Mr. Systrom's.
We have a very different idea of what the elected district attorney's job is. In fact, his criticism of me is that I'm not a career trial prosecutor. I tried cases for 1.5 years in that office when I first got there, and then I moved over to our appellate division. I've been an appellate prosecutor ever since. My belief is that in a county of this size, the elected district attorney doesn't need to be in the courtroom regularly trying cases, especially the high-profile cases. And that's because it's a big office. There's 40 prosecutors. We have a big county. We have a lot of stuff going on in here. If you've got a high-profile, complex case, that's going to demand a lot of attention and a lot of focus. And so for the elected district attorney to be devoting energy and resources to becoming personally involved in the trial of that case means that he's taking away from the management needs of the office. And I don't think that you can do both well. One of those is going to suffer. And my position in the race has been that you can look at the performance of the office under his administration and see that things have not gone well in some areas. And I think that's because too much time has been spent trying those high-profile cases and not enough time has been spent looking after the needs of the office and the prosecutors there. So my view is that the elected DA's primary responsibility is to make sure that he's got a good team of prosecutors, make sure that they have the training and resources they need to do their job. And that means bringing in folks from outside to come in and teach, because there's a wealth of information and training and resources in this state of great prosecutors, and they love to mentor and teach other prosecutors. That started happening recently at the office, but it hadn't been going on. The next thing is that prosecutors are all lawyers who've been through law school. They know how to think like lawyers. They have good judgment, or they shouldn't be working in the office at all. And so if those prosecutors are trained and you have an older, more experienced prosecutor working with them, then you need to trust their judgment, and you need to let them handle their caseloads, because we have a lot of discretion, a lot of room as prosecutors in terms of how to handle a case. And the elected district attorney shouldn't be micromanaging what those 40 prosecutors do with all those cases. There needs to be some ground rules, and then those prosecutors should have discretion to resolve those cases. And that's different than the way things have been as well. I think people need to be trusted to use good judgment. And then, you know, if they make a mistake and they believe they were doing the right thing, and the basis for them making that decision was right, but things just don't turn out the way they expected to, then you still support them in what they did. And if there's a learning opportunity that can come from that, then you learn from it. But you give people the freedom to do what they believe to be the right thing without fear of being punished arbitrarily if things don't go the way they think it is. Also, the elected DA's responsibility is to foster strong working relationships with law enforcement, because it's a team thing. You know, police put together those cases and gather evidence and round up witnesses, and they create this package of evidence, and then they hand it to the DA's office. And so it's the district attorney's responsibility to take that and make a case of it. And so there's got to be a good, strong working relationship. And prosecutors mess up and cops mess up, and they cannot learn from each other unless they have a good relationship where they trust each other's judgment, where there's feedback on a case when something goes wrong. And that requires time, and it requires energy of the elected DA. And I think that's what the elected DA should be spending his time on as well. And that also hasn't been happening. I've talked with a lot of law enforcement officers in this county. Under previous administrations, they felt like they had a really close and strong working relationship with the elected DA, Mr. Garino. They had regular interaction with prosecutors. Prosecutors would come down to the station and talk to officers. They would go on ride-alongs, things like that, where there was good communication and good trust. And that has deteriorated in the last 8 years. And again, that's not the fault of the prosecutors. I think that's the responsibility of the leader to create that environment and create that vision for this is what we're supposed to do as prosecutors. That's a long answer to that question.
Sometimes I think DA's offices reflect maybe the personality of the district attorney. In other counties, I've seen some offices that I would say were very, very aggressive. Some I would describe as almost passive, let them play kind of philosophy. First of all, how would you describe the current office here, and how might that change under your leadership?
I think currently the office has not been aggressive enough in dealing with cases in general. And by that, I mean that very often when enhanced punishments are available, there hasn't been a great effort to seek that. And I know just from working in Harris County a lot of times, and I can only speak of this anecdotally because there's no documentation where you can go and statistically look at this, but very often we would have criminals committing offenses in Harris County, and they would have a history from Galveston County, but there weren't those cases rather dismissed or never enhanced to a higher degree that we could then take that person's criminal history and use to increase their punishment range, which is appropriate when you have a habitual criminal. There's a lot of frustration in the communities about, and especially in law enforcement, about too many cases being dismissed and punishments that are handed out through plea bargains and things like that are far too minimal. And even things like DWI offenses, where, you know, by the second DWI you're at a Class A misdemeanor facing up to a year in jail. Your third should be a felony. But I've talked to so many law enforcement officers who arrest the same people over and over again for DWI, for example, and these convictions aren't there so that these repeat offenses cost more to the offender. And I think that's the responsibility of the leadership of the office.
Are they just getting pled down?
A lot of times they're pled down too.
So you don't get to have that, what they call it, the strike system.
Right, exactly.
Built up.
Your first DWI is a Class B misdemeanor, the second is a Class A, the third is a felony. But if you reduce the offense to some type of a Class C or some type of a non-DWI offense, like obstructing a lane of travel, to get rid of a case, then that person's criminal history never comes back that they have to be held accountable for. And so they keep getting these first ups at bat. And that shouldn't be, and that creates a lot of frustration in the community.